Hello and welcome back to EPG Pathshala. My name is Professor Soumya Uma. In the last of the 4 modules on the work of human rights NGOs, we will focus on the role of national and state level human rights NGOs in protecting human rights. The learning objectives of this particular module are: 1. To familiarize with various types of NGOs at the national and state levels. Second, to understand varied facets of the human rights work of national and state level NGOs. 3. To comprehend their strengths and the challenges faced by them. Let us begin with understanding the history of human rights NGOs in India. The definition of human rights in the Indian context, which has provided guidance to the work of human rights NGOs in India, was first spelt out in the Protection of Human Rights Act (PHRA) in 1993. This particular act says as follows: human rights mean the rights relating to life, liberty, equality and non-disparity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. This is the definition given in section 2D of the Protection of Human Rights Act of 1993. India has a long history of human rights NGOs which were active in cultural promotion, education, health and humanitarian relief in times of natural disaster during medieval times. During the colonial rule of the British, NGOs in India increased with a focus on providing literacy, education and various aspects of social welfare. Friend in Need Society, established in 1858, Arya Samaj in 1875 and the National Council for Women in India 1875 are some examples. In the early decades of 1900s, as the nationalist movement started, the focus shifted from developmental activities to economic self-sufficiency. After the independence of India in 1947, the civil society groups became invigorated as the government in the first 5-year plan recognized their potential to complement government efforts in creating social and economic development. The contemporary history of human rights NGOs in India has almost always been conceptualized in the post-emergency era. The severe repression of civil liberties during the national emergency between 1975 and 1977 motivated many individuals and organizations to take up the cause of human rights. Loosely organized groups of people working on human rights transformed into human rights NGOs once emergency was lifted. Human rights NGOs in India may be categorized based on different criteria. They may be categorized on the basis of their size, on the geographical scope of their work, on the thematic scope of their work, their organizational structure, or on the basis of their registration and the law under which they have registered their organization. Based on the size of the organization, large NGOs employ many full-time paid staff, receive a large grant each year that runs into crores of rupees. They have multiple donors, a huge corpus amount, several branches in several countries and are multinational bodies. Some examples are Aga Khan Development Network, Child Relief and You, Oxfam and Action Aid. Medium-sized NGOs have a smaller number of paid staff, but they receive tens of lakhs of grant every year, and they have a limited number of donors, a modest corpus amount, and operate in various states in India, either through their own branch units or in collaboration with other NGOs. Small NGOs have skeletal full-time paid staff, and they depend more on part-time staff and on volunteers, including student volunteers, and they receive a small grant for the basic administration of NGO and modest programmatic expenses, one or few donors, little corpus funds, and limited number of offices or branches. Given the smaller grant amounts that they operate with, they may function at the local or at the state level. Based on the geographical scope of their work, some address only local level human rights issues, others engage with state level issues. Naga People's Movement for Human Rights, NPMHR, Human Rights Organization of Manipur, Association of Parents of Disappeared People, APDP of Kashmir, and Andhra Pradesh Civil Liberties Committee, APCLC. These are some examples of state-specific human rights NGOs. Based on thematic scope of work, many human rights NGOs work on developmental issues such as health, education, housing, livelihood, and sanitation. For example, Pride India works on urban and rural development through health, education, and livelihood programs. Other NGOs work on civil liberties issues. For example, People's Union for Civil Liberties, PUCL, Andhra Pradesh Civil Liberties Committee, APCLC, Civil Liberties Monitoring Committee, which is based in Hyderabad, and Human Rights Alert, which is based in Manipur, are examples of such human rights NGOs which very clearly focus on civil liberties and civil rights related issues. In India, they also address human rights violations such as custodial torture, custodial killings and rapes, extrajudicial killings, enforced disappearances, illegal arrest and detention, condition of under trial prisoners, prisoners' rights, and the abolition of death penalty. Other human rights NGOs work on democratic rights as opposed to civil and political rights, and these include right to health services, medical negligence, consumer protection, right to education, livelihood rights, effective implementation of the National Rural Employment Guarantee Act, which is in short known as NREGA, abolition of corruption, encouraging women's political participation, election monitoring, rights of women, rights of children, rights of disabled, and environmental protection. Gandhi Peace Foundation is an example of such an NGO which focuses on issues related to democratic rights. Although the thematic scope of NGOs working on democratic rights overlaps with those working on developmental issues, in case of the former, a rights-based approach is adopted on a whole gamut of rights which is largely seen as socio-economic and cultural rights. The thematic scope of work for some human rights NGOs is humanitarian in nature. This means they respond to natural and human-made emergencies and disasters, and they complement the work of the government in rescue operations, in providing relief and rehabilitation. If we try and categorize the human rights NGOs in India on the basis of structure of the NGOs, we can say that human rights NGOs are structured differently. For example, there are pressure groups, campaigns, and activist networks. These often have a specific issue that they work on, and they are neither registered nor do they receive any funds. They are non-profit and voluntary organizations. Trade unions that advocate better labor rights, agrarian groups advocating for farmer rights, tribal and linguistic groups, environmental protection groups, people's movements such as Narmada Bachao Andolan and Chipko movements are some examples of this, which is activist groups and pressure groups. Another kind of human rights NGOs are what is called community-based organizations or CBOs. CBOs may have no or very low funding, and their primary work is with large communities of women, men, youth, children, migrant workers, domestic workers, and other vulnerable and marginalized groups. Though they are registered as legal entities, they may function in a very informal manner. A majority of human rights NGOs in India fall within the category of funded state or national level NGOs. Alternative Law Forum, which is based in Bengaluru, and Association for Advocacy and Legal Initiatives called AALI, ALI, based in Lucknow, are examples of human rights NGOs with a focus on making legal interventions. Butterflies and Tulir are examples of NGOs working on child rights issues. Environmental Action Group, Center for Science and Environment, and Bombay Environment Action Group BEAG are examples of NGOs working on environmental issues. National Campaign on Dalit Human Rights NCDHR and Navsarjan, which is based in Gujarat, work on Dalit rights issues. Some larger NGOs may have branches or units or offices in many parts of the country. PUCL, Lawyers Collective, and Human Rights Law Network are some examples of this, where they have branches or units in various parts of the country. NGOs together may form networks for increasing the impact of their work. Such networks would then function as large NGOs or coalitions with work in several states, but with a secretariat and with a coordinating body. For example, National Alliance of Women's Organizations called NAWO, N-A-W-O, has its headquarters in Delhi, and it works on issues pertaining to women's rights, and it prepares an alternative report to UN treaty bodies. On the basis of registration, Indian human rights NGOs may be classified as a public trust, a society, or a company under Section 25 of the Companies Act. A human rights NGO may be registered as a public charitable trust. There is no national law related to public trusts. State laws in the states of Maharashtra, Gujarat, Rajasthan and Madhya Pradesh have Public Trusts Act. Public trusts cannot usually be dissolved. A human rights NGO may also be registered as a society under the Society Registrations Act 1860. Societies are membership-based organizations registered for charitable purposes. Management plays a vital role in societies as they may have a large number of members. A governing council or managing committee plays this role. Unlike in the case of public trusts, societies can be dissolved. An NGO may also be registered under Section 8 or the old Section 25 of the Companies Act, which would give it the status of a company with limited liability, provided that no profits or other income are distributed in any form among their members. Now, let us try and understand the role and functions performed by Indian human rights NGOs. Major functions performed by Indian human rights NGOs include: 1. Awareness raising. Many human rights NGOs undertake information dissemination and public education at a mass level by conducting training, sensitization and skill building programs. Awareness raising may be undertaken through workshops, training programs, seminars and conferences. Production of resource material such as pamphlets, brochures and posters, and the widespread dissemination of such material also contributes to the process of awareness raising. 2. Research, documentation and publication. Many human rights NGOs undertake quantitative and qualitative research. Such research forms the backbone of campaigns and advocacy initiatives. Research undertaken may include fact-finding initiatives, an analysis of judgments and laws related to human rights, as well as a research on existing practices. Documentation forms an important part of a human rights NGO's work in India. For example, South Asian Human Rights Documentation Center and Asian Center for Human Rights, both based in Delhi, engage extensively in research and documentation on human rights issues. Third activity, campaign and advocacy initiatives. Many human rights NGOs are involved in campaigns on human rights. These may include law reform campaigns, campaigns on justice and accountability for human rights violations, as well as campaigns against laws, policies and practices of the government that may have adverse consequences for human rights. The right to information campaign, the right to food campaign, the right to education campaign are examples of campaigns where a large number of human rights NGOs have actively participated. Fourth activity, mobilizing public opinion. Mobilizing, shaping and influencing public opinion is a very important aspect of human rights NGOs' work in India. Such work is found necessary as a large section of the population may be ignorant of human rights ramifications of existing policies and practices, and they may be swayed by emotions, mindset, irrationality into adopting anti-human rights positions. A classic example of this phenomenon is the campaign to abolish death penalty, in which many human rights NGOs as well as civil society members have had to take a concerted effort to dispel myths around the necessity for death penalty. Fifth activity, providing legal aid and counseling to individual victims and groups of victims. They provide socio-legal, financial, psychological, medical and other forms of assistance to victims in distress, as this is an important component of human rights work of many NGOs in India. One example is the Majlis Legal Center in Mumbai, which represents women in distress in courts, particularly on issues of domestic violence, other forms of violence and matrimonial issues. Sixth activity, providing humanitarian aid and relief. Many NGOs have a specific mandate to respond to disaster management and to provide relief rehabilitation in context of natural and human-made disasters. Other human rights NGOs may not have a specific mandate. However, their mandate may be broad enough to allow them to help victims in distress in such contexts. One example would be the Latur earthquake of 1993. Another example, Gujarat earthquake of 2001, tsunami in the southern states of India in 2004, Kosi floods of 2008, Uttarakhand floods of 2013, and farmer suicides in Maharashtra in 2015, 16, 17. These are all events and incidents around which many human rights NGOs intervened to help victims in distress. Seventh activity, developing human rights norms and contributing to setting of human rights standards. Human rights NGOs in India have been responsible for expanding the rights discourse to include certain rights such as the right to development, right to housing, forest rights and environmental rights, which were not previously considered an integral part of human rights discourse in India. Some specialized NGOs have also analyzed the actions of successive governments in India using the yardstick of international human rights standards which are binding on India. Indian human rights NGOs participate in visits by UN special rapporteurs on a variety of human rights issues such as on freedom of religion, on human rights defenders and on violence against women. And they also prepare alternative reports for the consideration of UN treaty bodies on specific human rights. Now let us discuss the role of Human Rights Commission and human rights NGOs in India. The National Human Rights Commission, which we often refer to as the NHRC, is conceived as an autonomous body which was established through the Protection of Human Rights Act in 1993. One of the mandates of the NHRC as set out in this PHRA Act is to promote and support the non-governmental organizations and institutions working in the field of human rights. Accordingly, in order to utilize the knowledge, experience and expertise of human rights NGOs in India, the NHRC has constituted a core group with NGO representatives in 2001. It holds periodic consultation with them on various human rights issues. The core group of NGOs serves as a monitoring mechanism for the NHRC and it acts as a bridge between ground level realities faced by communities and the NHRC. The core group is reconstituted periodically to induct newer and credible NGOs within its fold from whose work NHRC can benefit. In taking the cooperation between NHRC and human rights NGOs further, in recent years, in addition, the core advisory groups have been constituted on specific human rights issues. These issues include bonded labor, health, disability, mental health, protection and welfare of elderly persons and right to food. Now let us discuss a case study, use of public interest litigation which is called PIL by Indian human rights NGOs. Many human rights NGOs in India have initiated PILs very effectively and they have sought recourse to judicial remedies to protect and promote the human rights of a large number of people, particularly sections of the poor and the needy. PIL is a litigation that is initiated for a public or for a social cause. As an illustration of the concerted efforts of NGOs, let me highlight to you all a few PILs that resulted in landmark judgments that have contributed to the human rights discourse in India. PIL number 1, People's Union for Democratic Rights PUDR versus Union of India. The judgment was delivered in 1982. In this landmark judgment, The PUDR alleged that in building a large sports complex at the Asian Game Village in Delhi, many labor legislations such as the Minimum Wages Act, Equal Remuneration Act and Contract Labor Regulation and Abolition Act 1970 have been violated. This led to exploitation of vulnerable people by contractors and employers. The petition was allowed by the Supreme Court and the Supreme Court issued appropriate directions to prevent exploitation of labor and violation of labor laws that protected their rights. PIL number 2, D.K. Basu versus State of West Bengal, judgment delivered in 1997. D.K. Basu, as the executive chairman of Legal Aid Services West Bengal, addressed a letter to the Chief Justice of India regarding deaths in police lockups and custody. He requested that victims' families should be awarded compensation and the concerned officers should be made accountable apart from developing a jurisprudence on custody. The Supreme Court treated that particular letter as a PIL and it responded very positively and it issued elaborate guidelines to be followed by the police at the time of arrest. These guidelines issued in 1997 have been popularly referred to as the D.K. Basu guidelines and these continue to be relevant and they continue to be referred to in a number of subsequent judgments related to deaths and torture in custody, illegal arrests and detention. PIL number 3. I am sure many of you have heard of this judgment called Vishaka and others versus State of Rajasthan. This judgment was delivered by the Supreme Court in 1997. Vishaka, a women's rights organization, an NGO based in Rajasthan, as well as other women's rights NGOs, petitioned the Supreme Court for laying down guidelines to protect women from sexual harassment at the workplace. Vishaka said that since there was no law in India to prevent sexual harassment at the workplace and to provide redress for the same, it sought the intervention of the Supreme Court to issue guidelines in this regard. Vishaka guidelines, as they are known, were issued in 1997, drawing upon international human rights standards and continue to remain applicable to prevent, protect and women from sexual harassment at the workplace. These particular guidelines, called the Vishaka guidelines, were operative till 2013 when a specific law was enacted. The name of this law is Sexual Harassment of Women at Workplace, Prevention, Prohibition and Redressal Act 2013. PIL number 4, Indian Council for Enviro Legal Action and others versus Union of India and others in 1996. In this case, a PIL was filed by the NGO in order to prohibit and remedy the pollution caused by several chemical industrial plants in Bichri village, Udaipur district in Rajasthan. In this particular case, the Supreme Court gave very favorable judgment and appropriate orders and directions to protect the ecology and prevent environmental degradation. PIL number 5, Citizens for Democracy versus State of Assam and others in 1995. This particular judgment focused on the rights of prisoners, particularly under Terrorist and Disruptive Activities Prevention Act, TADA. There were prisoners who were lodged in a hospital in Assam with handcuffs and they were tied with a long rope in the hospital to prevent their movement. So Kuldeep Nair, who was a journalist, wrote a letter complaining about this inhuman treatment to the Supreme Court and the Supreme Court treated that letter as a PIL and it stated that handcuffing and restraining the movement of detainees who are lodged in the hospital is inhuman and in violation of Indian law as well as international human rights standards. It clarified that handcuffing should be resorted to only if there was a clear and present danger of escape from police control based on clear material and not merely on assumption. This judgment has contributed greatly to the Supreme Court jurisprudence on prisoners' rights. Other PILs filed by human rights NGOs resulting in landmark judgments include Sakshi versus Union of India and others in the year 2004 and Naz Foundation versus Government of NCT of Delhi in the year 2009. The former was regarding guidelines and directions in cases of sexual violence, while Naz Foundation case was about section 377 of the Indian Penal Code, which criminalizes consensual adult sexual intercourse of a homosexual nature. More details of these judgments are provided in the notes of the module which are given to you. Please go through them. In conclusion, there are varied types of NGOs working with different focus areas, geographical and thematic scope in India. Human rights NGOs are also structured differently in accordance with their aims and objectives. The roles and responsibilities undertaken by human rights NGOs in India are diverse and expansive and are essential for the protection and promotion of human rights in the country. The National Human Rights Commission works in collaboration with well-established and credible human rights NGOs to serve the common cause of human rights. While the contribution of human rights NGOs in India is tremendous and in various fields, their use of PIL as a tool for socio-economic and legal empowerment of vulnerable communities is noteworthy. As said for the earlier modules, in this module 2, what we have discussed just now is not exhaustive. So, please refer to the notes that have been given which have more details. Please go through the reading given in those notes for a deeper understanding of the issues that we have discussed just now. With this, we come to the end of this module. Thank you.